Kentucky has a lease termination framework that operates under a dual system. Some parts of the state follow the Uniform Residential Landlord and Tenant Act, known as URLTA, while others rely on common law and older statutory provisions. This dual framework is one of the most important things landlords and tenants need to understand about Kentucky, because the rules that apply to your specific property depend on where it's located. Kentucky adopted URLTA in 1984, but with a critical distinction. The act only applies in counties that have formally adopted it through local government action. As of today, the major urban counties have adopted URLTA, including Jefferson County covering Louisville, Fayette County covering Lexington, Kenton County, Campbell County, Boone County, and several other northern Kentucky counties. But many rural counties across the state have not adopted the act, and in those areas, the landlord-tenant relationship is governed by common law principles, the lease agreement, and older Kentucky statutes. The practical effect is that a landlord with properties in Louisville operates under a different legal framework than a landlord with properties in a rural eastern Kentucky county. If you own rental property in Kentucky, the first thing you need to determine is whether your county has adopted URLTA, because that determines which rules apply. Let's start with no-cause termination. In URLTA counties, for month-to-month tenancies, either party must provide at least 30 days written notice before the termination date. Under KRS 383.695, the notice must be delivered at least 30 days before the next periodic rental date. So, if rent is due on the 1st and you want the tenancy to end on the last day of April, you need to deliver notice by April 1st at the latest. In non-URLTA counties, the general common law rule is that notice equal to one rental period is required, typically 1 month's notice for a monthly tenancy. The notice should still be in writing and delivered by a documented method, even though the common law doesn't prescribe specific service requirements with the same precision as URLTA. Written documentation protects both parties if the termination is later disputed. For fixed-term leases in both URLTA and non-URLTA counties, the lease expires at the end of the agreed term without additional notice required unless the lease specifies otherwise. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement. Landlords who don't want automatic conversion should communicate clearly before the lease expires and stop accepting rent after the term ends. For week-to-week tenancies in URLTA counties, 7 days' notice is required. In non-URLTA counties, the one rental period rule applies, 7 days for a weekly tenancy. Now let's cover termination for cause. And this is where the URLTA and non-URLTA distinction matters most. In URLTA counties, for non-payment of rent, the landlord must provide a 7-day notice to pay or vacate. Under KRS 383.6660, the landlord delivers a written notice giving the tenant 7 days to pay the full amount of rent owed. If the tenant pays within 7 days, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can file a forcible detainer action in district court. In non-URLTA counties, there is no specific statutory cure period for non-payment. The landlord can pursue eviction after providing reasonable notice that rent is past due. In practice, most landlords provide a written demand and allow a reasonable period for payment before filing in court. What constitutes reasonable depends on the circumstances, but courts generally expect at least a few days' written notice. For lease violations other than non-payment in URLTA counties, Kentucky uses a 14-day notice to cure framework. Under KRS 383.60, the landlord must deliver a written notice specifying the violation and giving the tenant 14 days to remedy it. If the tenant cures within 14 days, the notice is void. If the tenant doesn't cure, the rental agreement terminates 30 days after the original notice was delivered. This creates a total 30-day timeline from notice to termination for curable violations. For repeated violations of the same type in URLTA counties, Kentucky provides an escalation mechanism. If the same violation recurs within 6 months of a prior notice, the landlord can terminate with a 14-day notice without providing another cure opportunity. This prevents the frustrating cycle of violation, cure, and repeated violation. In non-URLTA counties, the process for lease violations is governed primarily by the lease terms and common law. The landlord should provide written notice of the violation and a reasonable opportunity to cure. If the lease specifies procedures for handling violations, including notice periods, cure rights, and termination consequences, those provisions control. Without specific lease language, the landlord must demonstrate that the violation is material, that reasonable notice was given, and that the tenant failed to correct the problem. For material and irreparable breaches in URLTA counties, violations so serious they cannot be corrected, the landlord can deliver a 14-day notice of termination without providing an opportunity to cure. Under KRS 383.660, if the breach materially affects health and safety and is determined to be irreparable, no cure period is required. Examples include serious criminal activity, drug manufacturing or distribution, substantial deliberate property damage, and conduct that poses an imminent threat to other tenants. Kentucky law specifically addresses drug-related activity. If a tenant is involved in the manufacture, sale, or distribution of controlled substances on the premises, this constitutes grounds for expedited eviction in both URLTA and non-URLTA counties. Kentucky's drug enforcement statutes provide additional tools for landlords dealing with drug activity, including the potential for nuisance proceedings against properties where drug offenses occur. The eviction process in Kentucky goes through the district court under a forcible detainer action. The landlord files a complaint after the applicable notice period has expired, and the court issues a summons to the tenant. In URLTA counties, the hearing is typically scheduled within a few days to 2 weeks. Kentucky's district courts handle a high volume of forcible detainer cases, particularly in Jefferson County and Fayette County, and the process is generally efficient. At the hearing, the landlord presents evidence supporting the grounds for eviction. The tenant can raise defenses including improper notice, failure to maintain habitable conditions, retaliation, and discrimination. In URLTA counties, the tenant has access to the full range of statutory defenses provided by the Act. In non-URLTA counties, defenses are based on common law, the lease terms, and constitutional protections. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant is typically given 7 days to vacate, though the court has discretion to adjust the timeline based on the circumstances. If the tenant doesn't leave voluntarily, the landlord can request a writ of possession, and the sheriff or constable carries out the physical eviction. The overall timeline from filing to removal is typically 3 to 5 weeks for uncontested cases. If the tenant appeals, the case moves to circuit court. The tenant may be required to post a bond to remain in possession during the appeal, typically the amount of rent that would accrue during the appeal period. If no bond is posted, the landlord can generally proceed with the eviction. On the tenant side, Kentucky provides several grounds for early termination, primarily in URLTA counties. If the landlord fails to maintain the property in a fit and habitable condition, as we covered in our Kentucky habitability video, the tenant in a URLTA county has remedies under KRS 383.635. The tenant must provide written notice specifying the condition that needs to be repaired. The landlord then has 14 days to make the repair, or less for emergency conditions that pose an immediate threat to health and safety. If the landlord fails to make repairs within the required period, the tenant can pursue several remedies. The tenant can terminate the rental agreement with at least 30 days' notice. Alternatively, the tenant can make the repairs and deduct the cost from rent, but the deduction cannot exceed 1 month's rent, and the tenant must follow proper notice procedures first. The tenant can also pursue damages through the court for the landlord's failure to maintain habitable conditions. In non-URLTA counties, the tenant's remedies for uninhabitable conditions are more limited. The primary remedy is constructive eviction. If conditions are so severe that the property is essentially unusable, the tenant may be able to vacate and argue that the landlord's failure to maintain the property constituted a constructive eviction that relieved the tenant of further lease obligations. However, this remedy requires the tenant to actually vacate and involves significant legal risk if a court later disagrees with the tenant's assessment of the conditions. Active duty military members are protected by the Federal Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Kentucky has a significant military presence. Fort Knox is one of the Army's major installations. Fort Campbell straddles the Kentucky-Tennessee border and is home to the 101st Airborne Division, and the Bluegrass Army Depot near Richmond also generates military rental demand. The SCRA provisions are widely used by military families across central and western Kentucky. Kentucky enacted protections for victims of domestic violence and dating violence under KRS 383.3002. A tenant who is a victim of domestic violence, dating violence, sexual assault, or stalking can request that the landlord change the locks on the dwelling unit to exclude the perpetrator. The landlord must comply within a reasonable time, typically within 48 hours. The tenant must provide the landlord with a copy of a valid protective order or other court documentation supporting the request. Kentucky also provides that a landlord cannot terminate a tenancy or refuse to renew solely because the tenant is a victim of domestic violence, and the tenancy was affected by incidents related to the domestic violence, including police calls or disturbances attributable to the perpetrator rather than the victim. This protection prevents victims from being penalized for the actions of their abusers. However, Kentucky's domestic violence lease termination rights are not as comprehensive as some states that allow victims to break their lease entirely with a specific notice period and limited financial liability. Tenants who need to relocate for safety reasons should consult with a domestic violence advocate or attorney about available options under current law. Kentucky strictly prohibits self-help evictions. Under KRS 383.655 in URLTA counties, landlords cannot change locks, shut off utilities, remove doors or windows, or take any action to force a tenant out without going through the court process. A landlord who engages in self-help is liable for actual damages and up to 3 months' rent, whichever is greater, plus attorney's fees. Even in non-URLTA counties, self-help evictions are prohibited under common law, and a landlord who bypasses the legal process faces civil liability and undermines any legitimate eviction case. Kentucky has anti-retaliation protections in URLTA counties under KRS 383.705. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant making a good faith complaint about a code violation or habitability issue, exercising any right under URLTA, or participating in a tenant's organization. The statute doesn't specify a precise presumption period the way some states do, but courts evaluate the timing and circumstances of the landlord's action relative to the tenant's protected activity. A clear temporal connection, such as filing for eviction shortly after a tenant's code complaint, creates a strong inference of retaliation that the landlord must overcome. In non-URLTA counties, anti-retaliation protections are based on common law and constitutional principles. Tenants can raise retaliation as a defense, but without a statutory framework, the burden of proof is heavier and the protections are less defined. From a practical standpoint, Kentucky's rental markets vary significantly. Louisville, by far the state's largest metro area, has a diverse rental market driven by healthcare, including Norton Healthcare, Baptist Health, and the UOFL Health System, logistics, including UPS's Worldport Hub at the Louisville Airport, bourbon and spirits, manufacturing, and the University of Louisville. Jefferson County's District Court handles a very high volume of forcible detainer cases, and the process is well established. Lexington, the state's second largest city, has a strong rental market driven by the University of Kentucky, healthcare, the horse industry, and Toyota's massive Georgetown manufacturing plant nearby. Fayette County operates under URLTA and has an efficient court process. Northern Kentucky, including Covington, Newport, Florence, and Erlanger, benefits from its proximity to Cincinnati and has a strong rental market. Boone, Kenton, and Campbell counties have all adopted URLTA. Bowling Green, home to Western Kentucky University and a growing automotive manufacturing sector, has a moderate rental market. The city has also become a significant refugee resettlement community, creating a diverse tenant population. Eastern Kentucky, including communities in Pike County, Floyd County, and the Coalfield region, has softer rental markets with more limited demand. Many eastern Kentucky counties have not adopted URLTA, meaning the common law framework applies. Landlords in these areas should invest in comprehensive lease agreements that address termination procedures in detail, because the statutory framework provides minimal guidance. Frankfort, the state capital, has a small but stable market driven by state government employment. Military communities near Fort Knox and Fort Campbell have rental markets heavily influenced by military BAH rates and the deployment cycle. Kentucky limits the security deposit to 1 month's rent in URLTA counties. There is no statutory cap in non-URLTA counties, though the lease should specify the amount. In URLTA counties, the landlord must return the deposit within 30 to 60 days. The statute provides a 60-day outer limit. The landlord must provide an itemized list of any deductions. If the landlord fails to return the deposit or provide a proper accounting, they may forfeit the right to withhold any portion of the deposit and may be liable for penalties. One best practice for Kentucky landlords: determine immediately whether each of your properties is located in a URLTA or non-URLTA county, and maintain separate procedures accordingly. Using URLTA procedures in a non-URLTA county won't necessarily cause problems. The URLTA standards are generally reasonable and defensible, but using informal common law approaches in a URLTA county, where specific statutory procedures are required, can result in invalid notices and failed evictions. Know which framework applies and follow it precisely. For the complete guide to Kentucky lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.